Afternoon, everyone. We still have a lot of people joining, but we're going to get started. We have a 1 hour time frame here, so I want to be respectful of everyone's time. My name is Tony Abuezi, and I am the current president of the Arab American Bar Association of Illinois. And first, I want to extend my thanks to all of you for joining us today. And I know it's a busy day. So we're going to keep it going real quick here. The CLE is free, so that's great. It's approved already for 1 hour professional responsibility credit in Illinois. During the presentation, we will be sending out a few reminders to email us your full legal name and your ARDC number to info@arabbar.org, and we'll put that in the chat 3 different times during the CLE here. In order for you to get credit, we do need that information. So please make sure that you send that to us and do so in a timely fashion. Also, if you are not a member of the Arab American Bar Association, but you would like to become a member, I would encourage you to visit our website, arabbar.org, and apply for membership. This CLE today will explore the exercise of free speech on campus and in the workplace. We have 3 excellent speakers who will be momentarily introduced. Moderating the presentation is retired Judge Bill Haddad, one of the founding members of our Bar Association, a close friend, a mentor. I actually clerked for him for 2 summers when he was in law division. And I really respect everything that he has done for our group. With that, I will turn it over to him to introduce our speakers.
Thank you, Tony, and congratulations in this your first year as president of our Bar Association. And I want to thank the men and women of the Arab American Bar Association, which is the oldest and largest Arab American Bar Association in the United States. I also want to thank our Continuing Legal Education Committee for helping putting this together, our co-chairman, Professor John Breen, and special thanks to Mike El-Karaki, who helped put this together today, and our techie people, past President Marvette Swice and Joe Holmesies, who are both with us today. Now, we are joined today with the leading First Amendment experts in the United States. And I mean, I'm not overstating it when I say they are the leading experts on this. We have with us Professor Jeffrey Stone. Professor Stone is the noted First Amendment scholar who is currently the Edward H. Levy Distinguished Service Professor at the University of Chicago Law School, where he was previously the dean. He is clerk for Supreme Court William Brennan, Supreme Court Justice Bill Brennan back in the early 70s. He will discuss campus speech issues from the standpoint of college administrators, faculty, and donors. We also have with us Professor Emerson Sykes, who is with NYU Law School. He is a Ruth Tilden Kern Scholar for Public Interest Law there, and he presently is the Senior Staff Attorney with the ACLU, the American Civil Liberties Union, Speech Privacy Project, where he focuses on First Amendment free speech protections. He will discuss campus protest issues. Professor Sykes is part of the ACLU team representing Students for Justice in Palestine, who have filed a suit against the chancellor of the Florida University system, which decertified that group for allegedly protesting Israeli policy in Gaza. And finally, we have Professor David Goldberger. Professor Goldberger is a professor emeritus of law at the Moritz College of Law at Ohio State University. He is a constitutional scholar who has argued First Amendment matters in front of the United States Supreme Court. He will discuss issues regarding American workers who were allegedly terminated or those whose job offers were rescinded for their outspoken views about Israeli policy in Gaza. And time permitting, we'll have an open discussion at the end of this, their conversations, and maybe I can take some questions from the chat room. Now, I'd like to set the stage a little bit, if I might, about why we put this together. The conflict in the Middle East has sparked outspoken criticism of Israeli policy. We've seen protests on campuses, in the streets, and on social media. Also, we have also seen a swell of hate rhetoric against Arab Americans, Muslims, and Jewish Americans. After the stabbing murder of the Arab American 6-year-old boy in Plainfield, Illinois, near Chicago, dubbed a hate crime, the Arab American Bar Association held a press conference at the Chicago bar here on October 23rd of last year. We were joined by Illinois Governor J.B. Pritzker, the Illinois Attorney General Kwame Raoul, and representatives of the Department of Human Rights. At that press conference, we publicly denounced the acceleration of hate crimes and hate speech against Arab Americans, Muslims, and Jews. But the AABAR also voiced concerns over certain tactics that were being used to compromise, if you will, suppress free speech by American citizens and students critical of Israeli policy in Gaza. We urged colleges and universities at that time to resist pressure to blacklist and discriminate against students protesting the Israeli policy. We also denounced the doxing of student protesters. Doxing is prohibited here in Illinois. We urged employers to refrain from punishing Arab American employees for voicing criticism of Israeli policy. And we called upon the Biden administration to establish a federal hate crimes commission like the one we have here in Illinois. However, our community ended up witnessing increased efforts to suppress criticism of Israeli policy in Gaza under the misrepresentation that criticism of Israeli policy was somehow a form of anti-Semitism, which most agree it is not. In the workplace, we saw reports of certain organizations pressuring corporate CEOs to sign workplace pledges to condemn, quote, anti-Semitism in all forms, which many had thought was really about criticism of Israeli policy. The American Middle East Voters Alliance here in Illinois received reports from employees of financial firms, for example, who were fearful of about these pledges. They were fearful of being terminated because of what they said in the workplace around media. The Washington Post reported that employees at companies like Google and Amazon who had called for a ceasefire were unfairly censored. The Washington Post reported that an Amazon employee said, quote, "A lot of us are dealing with harassment. They're scared to speak out." At colleges and universities, we saw what the Arab American Anti-Discrimination Committee called disturbing news of pressure by alumni and donors at universities and law schools, warning them not to tolerate students who demonstrate their views on the Middle East conflict. We saw letters sent to college administrators nationwide pressuring them to, quote, investigate, unquote, student protest groups for violating the Anti-Terrorism Act of 1996, which deals with material support of terrorists. It was not applicable, but that's what happened. We saw the White House direct 3 departments of the federal government, Department of Justice, Homeland Security, and Education, to, quote, consult, end quote, with campus law enforcement to investigate, quote, rising tensions, end quote, on college campuses. CNN called the Biden directive of these departments as, quote, implicitly equating protests against Israeli policy on college campuses as anti-Semitism. We even saw reports of pressure on legal educators and law students. National law firms were threatening to end recruitment from law schools which tolerated student protests, which were, quote, anti-Semitic harassment, end quote. There were reports of several law firms rescinding job offers offered to Palestinian law students. We had one who's a student member of our bar association who's filed suit with regard to that. And we've also seen reports of law associates who were terminated by some law firms for their outspoken criticism of Israeli policy. Now, our Arab American Bar Association here in Illinois conducts these ongoing diversity and inclusion CLEs. We've been doing it for over 4 years now, and they've dealt with issues such as affirmative action, diversity in law schools, diversity in law firms, voter suppression, and here we are with what I would call speech suppression affecting colleges, universities, student protesters, and American workers. So I'm very proud of the program. It's been successful, and we are extremely honored to have these three experts speak to us today. We're going to begin with Professor Jeff Stone. Professor Stone, as I said, will be discussing campus speech issues from the standpoint of college administrators, faculty, and donors. Professor Stone, please proceed. You're on mute. There you go.
You can hear me now? Great. Okay. Thank you. I'm delighted to be here, honored to be here, and particularly with these co-panelists. As Judge Haddad said, I've been asked to speak a bit about campus administrators, faculty, and donors in the context of freedom of expression on campus. Now, as a faculty member at the University of Chicago for the last half century, I should say I think that the University of Chicago is a model for these issues. It has, from its very beginning, been committed to the principles of free speech, free expression, the ability to argue and to disagree in a free and open manner. And this is a value that is essential to the university. That is, we are here to enable students and faculty to think for themselves, to debate with one another, to argue, to disagree, to learn, and so on. And if we think, for example, about changes that have developed over time, if you went back 50, 60, 70 years, universities might certainly have said that nobody can advocate for same-sex marriage. That's crazy. Or Southern universities before the 1950s would have silenced people who advocated for civil rights for Black Americans. So the reality is that throughout our history, universities have not been very good at dealing with these issues. In the late 19th century, early 20th century, universities for the first time became dependent upon large donors, and they recognized the power that they had in terms of telling the universities, I will not give you money unless you agree not to take particular positions, especially related to business matters. And these issues continued where universities routinely suppressed speech by taking positions on, say, World War I, where there was a great deal of controversy about the draft and about the war itself. And many universities took positions on those issues, saying that the draft is appropriate and the war is justified. And that was a central part of, during World War I, what universities did. During the communist era, universities themselves took official positions about communism, about its immorality, and saw that as a legitimate, indeed a necessary function of the institution. During the civil rights era, particularly in the South, universities took strong positions about their opposition to civil rights. During the Vietnam War era, there were universities that took positions either for or against the Vietnam War. The University of Chicago did none of that. And it did none of that because it is and has been committed to this principle of not being a player in public discourse and issues. And as I said, the reason for that is to enable and to facilitate free speech by students and faculty members. If a university does take positions on these issues, it will certainly chill the willingness of faculty members and students to take differing views. And that is completely inconsistent with the ultimate values of a university. In 1967, the university adopted what has come to be known as the Calvin Report, which was written by Harry Calvin, a professor of law, a specialist on the First Amendment, which essentially made very clear that at this institution, the university does not take positions on issues. And this is, I think, an essential component of our culture here. And what it does is enable faculty and students to take a wide range of views on all sorts of issues, whether it's abortion or the Middle East, or politics or whatever, without any concern that taking those positions will disadvantage them, because the university hasn't itself said that this is the right position on this issue or the other. And this is clearly something that universities should follow. It is a principle that has gotten a lot of attention in the last several months. And most universities have not adopted such a principle, in fact, until recently. But in the last several months, and particularly because of the issues that are now going on, universities have taken this view. And it's sometimes very frustrating. There are issues where the institution may want to take a position, but restraining itself is, in my view, central to the ability of faculty and students to take their own positions and argue openly and candidly for themselves about what they think to be right and wrong. The issue of donors and trustees is another facet of this. As I mentioned earlier, there's a long history of donors and trustees taking strong positions to try to not persuade, but coerce institutions to take positions they agree with and to enforce those views if they wanted to receive the donations that they could obtain otherwise. And this was, as I said, a major issue in the early 19th century, in the late 19th century and early 20th century, when businessmen began to do that in a pretty aggressive way. And as was mentioned earlier by Judge Haddad, law firms are now acting in this way as well. All of that is, in my view, inappropriate. They should not be attempting to manipulate the values of the institutions as a condition of receiving their donations. But of course, it's natural for law firms and donors to want to do that. They say, I don't want to give you money unless you take this position or that position. And the Calvin Report basically says that the university will not take positions, period. And one of the ways that works is that trustees at our university understand and respect that tradition. And they therefore do not take these views that if you don't take a position prohibiting speech about Vietnam or whatever, that we will not give you donations. And I think universities generally have to follow that example. And this is an essential way to become less vulnerable to these efforts to manipulate universities by making clear that we don't take positions. And if you don't want to give us money, that's fine, but we're not going to take money on the condition that we enforce or advocate a particular point of view. Now, in the recent episodes, this has been problematic, clearly, that there are law firms and donors and others who have essentially conditioned their support of institutions based upon the willingness of the institutions to take firm positions on these issues. And that puts enormous pressure on universities because they are dependent upon these donations. But at the same time, the best way to get to the point of having people not do that is by saying, no, we don't do that. And if it becomes understood that that's not a realistic way to affect the university and to get the university to take positions, then eventually that will become the norm. But it does take courage and it does take time. And it's also important in the university and dealing with donors and trustees for the institution to advocate a commitment to free speech, to make sure they understand that that's what this university stands for. That's how we seek understanding. That's how we seek knowledge. That's how we seek a better world, is by enabling universities and faculties and students and so on to take positions, to argue among themselves and with the public about what they feel is correct. And that is an essential component of what universities need to be doing. And there's a strong temptation to take views, but the university should not do that. And that includes the leadership of law schools, of business schools. Now, the individual leaders can speak in their own voices. They can say, this is what I think as an individual, but they should not be saying, this is what my institution thinks. That is essential to a long-term commitment to freedom of expression and academic freedom in the university. Thank you.
Thank you, Professor. And I should remind everybody that this session is being recorded. And if anyone has any questions to pose in the chat room, anonymously or otherwise, put them there and I'll see if I can bring them up later on. Now we have Professor Emerson Sykes, and he will discuss speech issues regarding student campus from the perspective of student groups and student protesters. Professor Sykes.
Thank you so much, Judge Haddad, and a pleasure to be with all of you, at least virtually. I wish we could all hang out afterwards and go out for coffee, but such is 2024. It's nice to be able to connect. So yeah, I want to focus a little bit on our work at the ACLU with students regarding free speech. And then I'll zero in specifically on the issues that we're talking about today. So when I joined the ACLU 5 years ago, part of what they asked me to do was help weigh into these campus speech debates. And quite quickly, what we realized was that what normally happens when there are campus speech issues that come up is people could bring in somebody who's pro-free speech, somebody who's anti-free speech, they have a debate, and everybody goes home as upset as they were when they walked in. And so what we tried to do was create a different strategy whereby we work with student leaders in between crises, primarily in between crises, where we try to help primarily progressive student leaders understand the deep values in free speech principles that are facilitative of their work, so that when inevitably something happens on campus, as we're currently seeing a current crisis on campuses, the idea was that we wanted to arm students with the information about where the legal lines are, why the principles exist as they do, and then they can make their own strategic decisions as activists about where they're going to push the lines, where they're going to break the rules. But my goal as an attorney and as an advisor to students has been to help them to understand their rights and understand not just what the rules are, but why the rules are the way they are. So through that work of working with student activists and trying to sort of help them develop these skills at a variety of different campuses, when a couple of months ago things got very heated on campuses, I'm proud to say that many of those folks reached back out to me and to my colleagues and said, hey, what are we supposed to do? What can we do? Employers are threatening to withdraw job offers. I'm scared to say, hey, whichever side of this issue I'm on, I'm scared to talk about it for fear of retribution. I don't know who's going to be listening. I don't know what the consequences are going to be. If I say nothing, people will be mad at me. If I say something, people will be mad at me. And my own institution, my alma mater is NYU Law, and I'm now teaching there. And it was in the eye of the storm. If you might have seen the coverage, the Student Bar Association president, so not a different kind of bar association, but the Student Bar Association president put out, I think it's fairly characterized as a strongly pro-Hamas statement without approval from the rest of the Student Bar Association. And I think it's fair to say that this statement went beyond Palestinian rights to actually sort of praising the attack itself. And I think that nuance is worth noting. But there was a lot of backlash and a lot of calls for folks within the community trying to figure out what are the rules, how do we react, what should we say and what should we not say. So going back to something that Professor Stone mentioned in terms of the Chicago principles, I have been preaching the gospel of the freedom not to speak, right? There are many times when you can achieve your goals best without necessarily putting out a public statement. There's a lot of pressure to put out public statements. People feel like silence can be so deafening. But at the same time, if you looked, I was paying close attention to the institutions that did put out statements. And every time someone would forward me a statement and say, oh, this is a good statement that this organization or this school or this university put out, my joke became, please also send me the retraction and the 3 other statements that they put out to clarify afterwards, because nobody was getting it right. It was impossible to get it right. So focusing on students, there were student groups who said, listen, this is happening to our classmates, this is happening on our campus, employers are terrifying us, what should we say and do? And what I told them and what I advised them was, take a moment, think about what your role is, think about what your organization is designed to do, whether it's the Black Law Students Association, the Muslim Law Students Association, the Progressive Law Students, whatever it may be. Think about what it is that you're trying to accomplish. Think about what it is that you should be doing with and for your members. And then think about whether a public statement achieves or doesn't achieve those goals. I think it's very easy to think somebody's got to do something. Let's put out a statement. And I just offer the idea that there's lots of things that I'm pro free speech. I'm a free speech attorney. I obviously advocate for free speech, but there's often lots of other things people can do to be active and to be supportive of their community without running afoul of these risks that Professor Stone talked about in terms of the Chicago principles and why it's worthwhile. The other thing is, you end up by putting out statements over everything. Then the question becomes, why didn't you put out a statement about this? I mean, some things are quite obviously big events, but there are other things that are big to some people and not to others. So how do you decide amongst them? I'll also say, just as a note before I get into the SJP case, from another note from NYU Law and the students, my course tomorrow, my seminar on the First Amendment, is going to be mostly empty because I got an email this morning that my students are participating in a walkout, a pro-Palestinian rights walkout. And this is really fascinating because there's a strong contingent of very strongly pro-Palestinian rights group students in my class. And what they have actually articulated themselves was what I think is an interesting generational shift. It's maybe a half generational shift that maybe Professor Goldberg and Stone can speak to even better than I can. But these very progressive, very left-wing students said, listen, in high school, I was very skeptical of free speech. It seemed like a talking point of the right. Academic freedom and free speech had been co-opted by the political right. But now it's my free speech that's at risk. And now I understand the value of free speech and academic principles. And so as much as sort of the free speech movement at Berkeley was led by the left, and then over the last several decades, the free speech and academic freedom has largely been co-opted by the right, I would posit that I'm seeing somewhat of a shift now, especially with these anti-CRT and other censorship laws being passed by right-wing officials, that we may be seeing another generational shift. So I have 3 minutes left, I think. Let me just talk a little bit about a specific case that Judge Haddad mentioned briefly. So the chancellor of the University of Florida system, of the Florida State College system, issued a memorandum to universities in the wake of the attacks in Gaza and Israel, saying that because of statements made by the National Students for Justice in Palestine in solidarity with the Palestinian Liberation Movement, he was calling for the deactivation of all chapters within the state. Now, there were only actually 2 chapters within the state, and they were immediately threatened with deactivation. The ACLU and many other organizations were alarmed. They received a lot of press coverage, and we did, as quickly as we could, we filed a federal lawsuit on behalf of Students for Justice in Palestine, saying that this deactivation order was unconstitutional. It was a viewpoint-based restriction on students. And so the state sort of argued that once we filed the lawsuit, the state changed tack and said, this is a dead letter and we're not going to enforce it. We've changed our mind. We didn't realize that the student chapters at the University of Florida and other universities are independent of national SJD, and therefore we should not have impugned the motivations of the national SJD onto the chapters. And so the state argued, there's nothing to see here, there's nothing to do here. We argued on the other side that this deactivation order remains in place. The chancellor has not removed it, even though the universities and others have said that they have no intent to deactivate these groups right now. The deactivation memorandum has never been formally withdrawn, and so we argue that the risk remains clear and real. The judge found that because of all of the statements by the government, including those internal memos, there was not actually a credible threat of imminent enforcement, right? In all intents and purposes, the judge found that the state had in fact withdrawn the deactivation order. And so he dismissed our case on standing grounds, but he took pains to note that he understood why the students were concerned. He recognized the students who were sitting in the audience, and he said, listen, what they have threatened you with is terrible. And I understand why you are worried about that. And so I think we can take heart in the fact that he understood why this was an important issue, even though the case was dismissed. And I'll just say, there was even an article today, an op-ed written today, basically saying all of the press got this wrong, because many of the headlines say, DeSantis wins, ACLU case kicked out of court. But I would argue that's not quite what happened. What we had was the state of Florida did something totally egregious, realized it, pulled it back, and the judge said, I'm going to wait till they try it again before I take action. But I think he was unequivocal in showing that the First Amendment was important and that this raised important concern. So this case for now is no longer active, but we are heartened that for SJP, the student chapters of SJP can continue to do their important work. And we want to protect speech in these times and in all times, even when it's uncomfortable, even when it's difficult, even when those in power find it uncomfortable.
Well, thank you very much, Professor Sykes. We're now going to proceed to hear from Professor Dave Goldberger, who will discuss speech issues regarding American workers. Professor Goldberger.
I'm glad to be here and honored to be here, Judge. I want to start out by noting the debate over the war in Gaza has generated free speech casualties across the country, and you know, as you've noted, as Professor Sykes has noted, and implicit in Professor Stone's comments, this is an ongoing and very serious problem. A leader in this debate with a group, the Anti-Defamation League, and I'm going to take advantage of my opportunity to chat here to be perfectly candid about my feelings about what's going on. There's been a Jewish anti-discrimination group that has done an enormous amount of good over the years, but there have been excesses, and there are excesses right now. To talk personally, years back when I was with the ACLU in Chicago, I was representing the Nazi Party in its efforts to speak in Skokie, and the ADL filed a brief that identified me as addressed me as neo-Nazi counsel. It was only after saner heads and cooler heads intervened that I received an apology. But it seems to me that some of the things I'm reading right now are over the top in a somewhat similar way. And hopefully, as I say, as tempers cool and become more objective, we'll see everyone start to look at everything more objectively. The obvious question is whether there are any legal protections prohibiting discrimination against pro-Palestinian employees and applicants for employment. And I come bearing sad news, obviously. For the most part, the answer is no. Discrimination based on political beliefs in the private sector does not violate federal law and does not violate the law in most state jurisdictions. There are some states to the contrary. The basics. The First Amendment does not protect against freedom of speech in the private sector. It only protects against government censorship. There has to be state action, which is a benchmark for First Amendment protections. Private employers are not state actors. As a general rule, there's no state action when the private employer is fulfilling a government contract. However, there can be anti-discrimination provisions in the contract. And that's something you'd have to, as lawyers, take a look to see what those provisions are or if they even exist. Still, I'm personally unaware of federal contracts explicitly protecting against viewpoint discrimination. Typically, those contracts, when they have anti-discrimination clauses, cover the same classes as are covered by Title VII, which again does not prohibit discrimination based on political views, association, or advocacy. Indeed, Title VII of the Civil Rights Act of 1964 does prohibit discrimination based on race, color, national origin, religion, and sex. And in order to be protected by Title VII, a client must be a member of a protected class, which is a class specified by the statute. The employer must know of this membership, the employee must suffer harm from the alleged discrimination and must be treated worse than other employees. I believe this would also extend to withdrawal of employment applications or employment offers as well, not just someone who's currently employed. And again, while it's disturbing to hear of the withdrawal of offers to pro-Palestinian law graduates, for example, or those who have graduated from business school and are trying to work in the finance sector, they're at-will employees as far as the First Amendment is concerned, as a general rule. Now, perhaps there is coverage if the advocacy that is discriminated against, if you will, is simply evidence in a case in which the discrimination is alleged to be class-based, based on race, national origin, and so forth. But standing alone, and that's very difficult. It's a long shot to be thinking that way. And I think it's a mistake to think that it really is much of a protection at all. But there it sits. Some states have laws prohibiting discrimination by private employers against lawful off-duty advocacy. And North Dakota and California law prohibit discrimination. These are examples based on lawful off-duty and off-site activities. Connecticut, now those are activities. The statutes do not explicitly talk about First Amendment activities, but they just say off-site activities and so forth can't be a source of discharge or job disability of any kind. Connecticut explicitly bans discipline for private employer, by private employers against employees for advocacy. That violates the First Amendment. So they basically, Connecticut has adopted the First Amendment as its benchmark statutorily and said, you can't discipline an employee for exercising his First Amendment rights. However, Connecticut law does not protect speech activities that interfere with the employee's duties. And I presume that protections in the other states have the same exception. I did not do a complete search of all states. So if anybody participating here has an issue, they're going to have to check the law in their particular state. In sum, I think it's fair to say that most activist critics of Israel who speak out against, for example, the massive bombing of Gaza, they face vulnerability in obtaining or retaining private sector employees by employers who object. The protections are at a state level, if at all, and they're sparse.
Thank you, Professor Goldberger. And we have some questions from the chat room, but we could begin with an open mic right now with the three of you. And I would ask Professor Goldberger and the others, when we talk about Titles 6 and 7 of the Civil Rights Act of 1964, there is the requirement of state action. Now, I'm not William O. Douglas. I don't want to make this a broadly based analysis of what is state action. But what about law firms and construction companies who do business with city government, state government, that start to curtail the rights that we're talking about? And the same with universities and colleges that receive public grants from the federal government for research and so on. Is there some way of applying the Civil Rights Act to their activities?
It's my view that unless there is a federal statute or a provision in the contractual relationship that explicitly covers it, there's no protection. And I know of no federal statute that would cover basically the subject matter that you just described.
It was one of the people that one of the listeners who posed a question about the First Amendment rights on campus talked about Title VI and the balancing of the ethnic intimidation issues and the hostile environment on campus. So I thought I'd pose it in that way. Anybody else want to chime in on that, by the way?
Sorry for the background noise. Literally, President Biden is leaving on a helicopter right outside of the office. I don't know if you can hear it, but that's why I was on mute. I don't disagree with anything Professor Goldberger said. The only thing I would just pick up on is this idea of government speech. Because as Professor Stone knows, this is an issue that has grown. It has sort of been an exploding doctrine, this idea that, no, the First Amendment doesn't cover that. That's government speech. And that has become sort of a go-to justification for speech regulations, is somehow painting this speech as actually coming from the government itself. And this is happening in the higher education context as well. One of the other cases that I work on, which I think is tangentially related, you'll indulge me for a moment. There's a case in Florida called Purnell, which is challenging the Stop Woke Act as it applies to universities. And the Stop Woke Act was an idea of Governor DeSantis, and it has a list of divisive, prohibited concepts that you're not allowed to teach in class, including things around affirmative action, implicit bias, privilege. All those sorts of things are no longer allowed to be taught according to this law. We successfully got an injunction against this law, and so it's not in effect on Florida classrooms. But the argument that was put forward by the state is shocking. What the state said is that everything that happens on a college campus essentially is government speech. Anything that's related to curriculum in any way is the government speaking on its own behalf. The government, as they argue, the government pays the professors. The logo of the university is on their door. It's on their paychecks. It's on their business cards. Clearly, they are employees of the university. The university is clearly a government entity, and therefore, these professors are simply public employees at work with no strong First Amendment protections for their speech, essentially like a DMV employee. No shade on DMV employees, but I think we think of a DMV's clerk's speech rights as different from a university professor. So I just bring this up to say that it's a really dangerous idea that we can continue to expand government speech to encapsulate things that we have traditionally thought of as private speech. And I think that university professor speech, we've argued, deserves its own category. Yes, they are technically public employees, but they should not be subject to any of the same sorts of calculations that other public employees are, because, as Professor Stone started with, the whole endeavor of the university is different. The whole point of the university is not to execute government policy. It's to foment knowledge, right? It's to teach, it's to learn, it's to expand our human wisdom. So I think when we hear these arguments about government speech, it sort of always makes me a little nervous because of where that doctrine in and of itself is going.
Great. There's a question that arises regarding the Wall Street Journal opinion piece that was out recently that was entitled, Welcome to Dearborn, Michigan, America's Jihad Capital. Now, this has been criticized soundly by many people. The mayor at Dearborn had to ramp up police security for churches and mosques because of an alarming amount of bigoted and Islamophobic rhetoric targeting the city of Dearborn after that article was publicized. And this raises the issue of campus speech, hate speech. You know, when does it cross the line? Is there a line? Is there a code of conduct? Does the media, the Wall Street Journal, the university, Harvard University, or any of these entities have any kind of duty to curtail or monitor speech that would be otherwise protected but crosses the line that would become hate speech that could result in hate violence on campus or in the city of Dearborn or anywhere else? What obligations do universities and companies and entities have in monitoring issues such as hate speech that becomes or could result in hate violence, otherwise protected?
Yeah.
I was going to ask Professor Stone that question. So anybody can answer it, though. It's fine.
Well, the first thing worth noting is that the Supreme Court, without a single exception, both Republican-appointed and Democratic-appointed justices have held that hate speech is protected by the First Amendment and is not a category of speech that can be restricted because you call it hate speech. And that, as I say, that includes even justices like Elena Kagan and Antonin Scalia. The reason for that is in part that it's very difficult to define what one means by hate speech. And that's the problem with things like obscenity, and we've always had these problems. But the court has basically said that there's no history of laws restricting something called hate speech, and it would be inappropriate to create this new category. Now, it does exist in the real world, whatever it is. There's no doubt that there is speech that exists out there that is harmful, at least emotionally, to people because of the message that it communicates. But basically, the notion is that's just too vague a concept to allow it to be regulated. Now, that doesn't mean that a private entity could not regulate it if they wanted to. They could. The First Amendment wouldn't prohibit them. But the problem would be, how do you define it? And the danger is that it gets applied in a way that is biased in itself. That speech that is regarded as hate speech against one group would be regarded by whoever is making these decisions as hate speech, and the same type of speech directed at another group that they're not very sympathetic with would not be regarded as hate speech. And so the danger there, even in the private sector, is that it gives a power to restrict speech in a way that's not easily determined. and therefore should not be implemented.
What about codes of conduct on college campuses? We heard a lot about that regarding our Harvard. I think the provost at Harvard who resigned. They talked about in the Senate or the House about the committees talked about codes of conduct and violations of codes of conduct. I mean, is that relevant to this discussion?
Well, yeah, I mean, I think just going back briefly to your previous question, I mean, when you have a few First Amendment folks, whenever you use the phrase hate speech, automatically our whole nervous system jumps. But I think a related idea is harassment, right? And so if we're thinking about when does it cross the line to being actionable, as Professor Stone said, hate speech is not a category, but harassment is, right? And so when we think about whether it's harassment based on gender or harassment based on race or other protected characteristics, there are hard questions about where free speech bumps up against harassment. And I think one of the things that we've seen developing in the case law, and there's actually a pending cert petition, there's in the Supreme Court from an organization called Speech First that has really been pushing hard on this boundary in universities. And what they have been doing is going after university harassment policies and trying to get them struck down as unconstitutional if they in any way cover protected speech. That is, if they go beyond the First Amendment definition of harassment, or there isn't really a First Amendment definition of harassment. There are a few definitions of harassment, but they're basically about severe, pervasive, or objectively offensive conduct, severe or pervasive conduct that creates a hostile learning environment. There's this idea that certain kinds of speech should be considered conduct because of the impact that it has on somebody else, because it doesn't allow them to actually participate in the educational environment or in the work environment. So what we've seen is that if universities and private employers must act when there is harassment, which they must, right, by federal law, but at the same time, they are prohibited from acting on anything short of harassment, then they're really in a tough position, right? Because then they are prohibited from acting until the very moment that they are required to act. And so this, I think, highlights the ways in which the sort of space between the harassment idea and free speech has really been closed to such a degree that it's really hard to know if there's anything a public entity can do to address speech that is not harassing, right? And so colleges have attempted to get around this and by saying, okay, listen, we're not disciplining you for the viewpoints you expressed, but we're going to call you in and we're going to have you meet with somebody and we're going to talk through why we think this was really a harmful thing to say and why we don't want this in our community. This is not a disciplinary action. We are not opening investigation. We are not punishing you for your ideas, but we are taking official action to address it. And even that has often been found to be chilling of protected speech. And so it really does leave institutions in a tough position, I think.
I'm going to give you a last question now, and is this, does the White House directive that I mentioned earlier in my remarks to federal agencies to investigate so-called tensions on college campuses caused by protests, could that or might that constitute an abridgment of a citizen's right to criticize foreign policy, Israeli policy, any policy under the First Amendment? And by the way, don't forget Supreme Court Justice Jackson's definition about I know it when I see it. Maybe that could be applied. All right, fine. If you would address that question about federal investigations, whether they could be an abridgment. I note silence here. Okay, Emerson, you're the guy.
I think there are certainly ways in which we can think about different ways that First Amendment speech can be burdened. I was just talking to a colleague about this issue recently because it came up in one of our Ninth Circuit arguments around a prison law case. The First Amendment doesn't only apply when speech is prohibited. It can also apply when speech is burdened, right? So depending on the situation or the fact pattern, there is a way in which, public entities can burden private speech indirectly. And that's a question also that's in front of the Supreme Court. What can especially in the context of social media platforms. And maybe this is going a little bit too far afield. But I think what the heart of the question is, when can it be impugned to the government if it's acting indirectly to squelch speech? And I think the answer is yes, sometimes, but the actual outlines of when and how are still being defined. And in a year from now, we should actually have a much clearer answer.
Mhm.
Let me just add,
Jackson's quote was, I can't define it, but I know it when I see it. That's what I meant about hate speech. But anyways,
but let me add a sentence here that fortunately or unfortunately, and it's not a debate I want to raise, the courts are very deferential to investigations by legislatures and by government entities, as opposed to specific and concrete action. And I think there's no question that the threat of investigation is intimidating, but it seems to me that it's going to be difficult to get an injunction, for example, against an investigation, as opposed to an injunction against something that has an actual bite, sanctions.
thank you. Good. Well, we've covered the areas pretty well. I want to thank you for this insightful discussion. I want to thank Professor Stone, Professor Goldberger, and Professor Sykes for participating in this. I know you are all busy and you took the time to educate us in this CLE today. I want to also thank again our CLE committee at the AABAR and all the attendees today and colleagues who were present for this. With that, I'll bid you all goodbye. Don't forget to submit your ARDC numbers to info@arabar.org. Have a good day, everybody, and thank you. Gentlemen, thank you very much.